A fair market. They're going to do a fair market value. Okay. The court's allowed to order allowance, accounting, contribution, or other compensatory adjustments. So they're allowed to look at, you know how that goes. Oh, I paid all these years for the insurance and I paid the mortgage more than he did. And you know how that goes. So you're allowed to throw all that at the court so that when they distribute the assets, they know all of that stuff. That's all part of what the court will do. Okay, the court can issue a temporary restraining order. If someone's hurting the property, you want to sell it, and the other person who owns it lives there and these are the reasons: preventing waste. So they're making the property worthless, protecting the property or title to it. So if there's any reason to get a restraining order, you can get a restraining order. So that it's not like you're sitting around and then meanwhile the person's going to trash it or going to do something if you can prove that. Okay. Court procedure, okay? If any co-tenant, I guess they call them co-tenants, but co-owners, request partition by sale, the court shall, after the determination of value, send notice to the parties that any co-tenant, except a co-tenant that has requested partition by sale, may buy all the interests of the other co-tenants. Okay, so this is the first the court gets this. They say, okay, we're going to have a partition action. Let's establish the value of the property. We establish the value of the property. And then if you weren't the one who filed the partition action, then, or I guess if you didn't object to it, then you would be in that boat too. Then you don't have the right to buy the property. If you're the one who filed the partition action, then you don't have the right, but the other people have the right. If there's one other person or more, they have the right to purchase the property from the court. Okay, so after not later than 45 days after a notice is sent under A that you have the right, any co-tenant except a co-tenant that requested partition by sale may give notice to the court that it elects to buy all the interests of the co-tenants that requested partition by sale. So, of course, at the beginning you have to determine who owns how much of the asset, right, of the property. So assume it's 50-50 because probably mostly in our circumstances it is, but it doesn't have to be. You could have two 25% owners and a 50% owner. You could have any combination, right?
Cindy, quick question, just for verification. I want to make sure that I understood it. So the person who's filing the partition can or cannot purchase the property?
Cannot.
Cannot. Okay, thank you.
And I assume that's because they're saying, well, you came to the court and told us to sell it, so
okay,
that's what we're going to do. And,
okay.
so the other side has a chance to buy it. Okay.
Does this apply to acquiring it from a trust and also husband and wife?
Okay. Partition actions between husbands and wives are usually heard in divorce. You can't have a partition action between two people who are married. That goes to the family law. I read a lot of stuff, and one of the examples I read, if it was correct, was a husband and wife who at divorce agreed to co-own a property. And then later on, when they weren't married anymore, then somebody partitioned it. But yeah, if you're married, you probably get the same exact thing, but you have to do it through the family law court.
Makes sense.
Yeah. That's what I thought too after I looked at it. I go, yeah, why would they do that here? Okay. Okay, so you gave notice to the court. I didn't want to do this in the first place. It's been in my family for 100 years. So I'm going to buy your interest. I have 45 days to determine that I want to buy your interest. The sale value of the parcel determined. Right. Okay. So the purchase price is the value that was determined multiplied by the co-tenant's fractional interest. So if they own 50%, it's half of what the appraisal was. Okay, so let's assume that this 45 days go by and nobody requests to buy the house, the property. Okay, so after expiration of the period, if one co-tenant elects to buy all the interests of the co-tenants that requested partition, the court shall notify the parties. If more than one, this just goes into if there's more than, say, the 4 people on the property and 2 of them want to buy it, but not one. So this just talks about how that works. It's not the kind of thing you're going to remember forever. So if you ever have it, we're going to have to go over this part again. If no co-tenant elects to buy all the interests of the co-tenants that requested partition by sale, the court shall send notice to all the parties of that fact and resolve the partition action under paragraphs A and B of 84-318. And here they are. Okay. If all the interests of the co-tenants that requested partition by sale are not purchased, the purchased or after conclusion of the buyout, somebody doesn't pay or something, the court shall order partition in kind unless the court, after consideration of the factors, finds that partition in kind will greatly prejudice to the co-tenants as a group. Okay, so this comes from feudal way back, like, you know, like feudal law, where instead of selling it, they would just cut it in half and say, you take that half and you take that half, right? Because these were, you know, big landowners and whatever. We can't do that anymore. You know, things have changed, and, you know, you can't just cut a house in half or a property in half. It doesn't work like that. And so, although they say that at first it will be a partition in kind, which means everybody gets a piece of the actual property, if that can't be done, and maybe it can be done, maybe there's ways to, but if that can't be done, it can't be done. And then they have to sell it. Okay. If the court does not order partition in kind, the court shall order partition by sale pursuant to this other statute. If no co-tenant requested partition by sale, the court shall dismiss the action. So if no one wanted a partition by sale, they only wanted partition in kind. I just can't imagine in anything that any of us are going to do in our lifetime, we're going to ever have something that's partition in kind. It's always going to be by sale. Okay. So partition in kind is when you can actually divide it up. There are 7 factors considered in determining if a partition in kind can be made. And the most important one is whether the property practically can be that's supposed to be divided, not decided. It's supposed to be divided, right? If you can't do it, then that's it. That ends the conversation. And that's the case with, you know, 99% of our single family homes. You can't just divide them up. So we can't have it. Okay. By appraisal, the property is appraised and sold. They divide up the proceeds fairly. This would happen with a single family home, being that you can't split the home in half. If one of the owners wants to buy out the other, it can be done after property is appraised. If the court orders a sale of the property, the sale shall be open market sale unless the court finds that a sale by sealed bids or auction would be more economically advantageous. Okay, so it's going to be an open market sale, which is what we do. Okay, if the court orders an open market sale and the parties not less than 10 days after entry of the order agree on a broker, then the court will appoint the broker and establish a reasonable commission. And as happens many times, if 2 people are fighting, they can't agree on a broker. The court can appoint a disinterested real estate broker licensed in the state of California to offer the property for sale and shall establish a reasonable commission, which I guarantee will be higher than the reasonable commission they'll give to the one you picked, right? If they're going to use one of their inside people. So better to agree that we have 2 brokers. You put one in and I put one in the co-list. Better to do that than have the court ever appoint anything for you, because there's always going to be extra charges. Okay, the broker shall offer the property for sale in a commercially reasonable manner at a price no lower than the determination of value on the terms and conditions established by the court. So the court will say, you know, one party will go in and say, well, I need to stay an extra 30 days. Okay, when you sell it, you have to carve out 30 days for this person to move, you know, whatever things people ask for, they'll put those in the terms unless they're unreasonable. If the broker, this is really weird because there's no timeline, there's no dates, and I don't understand what this means. If the broker appointed under subdivision B obtains within a reasonable time, whatever that is, an offer to purchase the property for at least the determination of the value, the following requirements apply. Oh, I don't know what that is. Okay. It looks like an unhappy face, but it's not meant to be that. The broker shall comply with the report requirements. Okay, so we're going to get into that. You have to file a report. The sale shall be completed in accordance with state law. So it's our regular sale, regular documents, regular everything. If the broker appointed under subdivision B does not obtain an offer to purchase the property for at least the determination of value within a reasonable time, the court, after hearing, may do any of the following. So you're one of the parties, you don't really like the broker, you think he's not doing a good job, it's been 3 months, there's been no offer. So this is what the court can do. Approve the highest outstanding offer if they didn't bring one in at the valuation. So, Judge, I've tried to sell it. I have 10 offers, but none of them are that high. We have it overpriced. Redetermine the value and then go back and try to get more, give them more time and try to do something else. Order that the property be sold by sealed bids or an auction. So if you get to be the broker, you have to sell it within a reasonable time or they're going to take it away from you. The court will. Okay. And I've never seen that happen, but you just never know. Okay. Okay, so the broker who is appointed to sell the property has to file a report with the court not later than 7 days after receiving an offer to purchase the property for at least the value determined. So it has to be at least at value. Okay, then the report just there's 7 things that have to go in the report. They all make sense, nothing weird here. Again, this isn't something you're never going to memorize these 7. If you ever need to do one, you're going to need to go back and look again. But there are 7 things that have to go in, and they probably have a form for the report too. Okay, so costs of partition, okay? In an action for partition, the court may apportion the cost of partition, including an appraisal fee, except that the court shall not apportion the cost of partition to any party that opposes the partition unless doing so is equitable. So if someone has a reason and they oppose it, but the court's got to do it anyway because partition is absolute, they have a right, but I can't make this guy pay for it who didn't want to do it at all. But it says unless they found it equitable. So my guess would be, my educated guess would be that the court the person would have to have a good reason why they didn't want it partitioned. Okay, they go to the court and say, no, we can make more money this way. No, we can do this. No, this is, it's been in my family for a long time. I don't want to do that. That would maybe change the equities. Okay, so that you might have to do that. Okay, but just so you know, the person filing then is really responsible for the costs. Okay, there's also partition by judgment. I don't think I don't think you guys are going to get into that. The partition's always going to be by appraisal and sale. That's what we do with single family houses. Okay, so does anyone have any questions on partition actions? I know, I don't know if you guys get called. I get a lot of calls about people owning property with someone they don't want to own property with. So that's what they would do. They would go to court. They have, again, an absolute right, so they're going to win. And normally what happens in a partition, in a partition action and probably in a specific performance also, is that if they get a good lawyer, if the parties get a good lawyer, they're going to know they can't win, right? You can't fight this. Because the lawyer's going to say they have an absolute right. There's nothing you can really do other than try to get whatever terms you want or try to. So most of the time people are more cooperative when the law is so black and white, right? Because if they're going to lose, they might as well work on settling rather than just letting the court decide certain things.
Cindy, what's the timeline on this? How long does it usually take?
I read that it takes 2 to 3 years. But again, I feel like, it depends, right? It depends on how fast you move it. If you guys walk into court and you say, hey, we've agreed on a price and we've agreed on a broker, but we need and if we did that, why would we need the court, right? If we already could agree on a price and a broker, why wouldn't we just sell it without the court? But assuming that we can't agree on, I don't know, anything else, but it depends, right? If you don't need an appraisal, you're going to save the time of an appraisal. If you don't need,
So bottom line, if one party does not want to sell, there's 4 of them. I'm in a situation like that right now.
Yeah.
One party, the other brother does not really want to sell. He would be forced to sell, correct?
Correct. In the end, the court will say, sorry, we're going to sell this. But if the 4 of them can agree on the price that we're going to offer it at, or they can agree on a broker, then that's 2 hearings, maybe 2 months that you're saving, right? That, you know what I mean? Because what's going to happen is the court's going to say, do you guys agree on a broker? And everyone's going to say, oh, I don't know, dear. And then he's going to say, sure, you guys go back. We'll meet again in 6 weeks. Come back and tell me who the broker is going to be. That's how it goes. Right? We're not in any hurry. We're the court. We're just like, come back in 6 weeks and figure it out. And then they come back and they go, we couldn't figure it out. And the court goes, okay, well, I'll appoint someone. You'll get it in the mail. Right? You can draw it out and you can shorten it depending on, how cooperative. But again, I always feel like in these kind of actions, if you have a lawyer who's halfway decent, they're going to tell you that you're just wasting your money. Right?
Yeah, I agree. We're on the 2nd year already and there's still nothing.
Oh, yeah. Right. You can drag it out, right? There's a million ways to drag it out. Yeah. So
are all of this attorney being paid by contingency or by the hour?
No, because there's nothing I mean, you can always make any deal you want with your attorney, but I've never heard of contingencies in anything but like personal injury.
Got it. Okay.
Right.
Thank you.
Okay, where are we? So the name of each buyer. Oh yeah, no, we're way down here. Okay, Liz pendants. Let's do okay. Liz pendants also called a notice of pendency of action. Okay, there's nothing else in the law like a Liz pendants. It's just so different. And really all the Liz pendants does is you record it and it tells the world, I have a lawsuit. It tells the world, I have a real property claim, meaning the cause or causes of action in a pleading, if I win, means affects title. So if you want to buy this house, and they I don't know if I put it in here, but they had an example of someone who decided to buy a house anyway, even though there was a Liz pen. The people won at trial, the seller won, and the buyer appealed, and somebody else bought the house. Title won't insure title, so I don't know how they get around title, but they maybe they pay all cash. I don't know. But anyway, in the end, the appeal won, and the person had to give the house back because they bought it with a Liz pendants pending. That's why title won't insure it. So if once the Liz pendants is on the property, you can't do anything really with the property. You can't refine it. You can't do anything because we don't know who owns it. It's saying we don't know who owns this property. So you better beware if you're going to do anything about it. Okay. Okay, when can you file it? Okay, you have to have, that's not a very good answer to when. You have to have a lawsuit filed that allows you to file a Liz pendants. A lawsuit for, we're going to go into that for specific performance. It could be a lawsuit for partition. But I don't understand how, I read that partition people can file a Liz pendants, but I don't, if you both own the property, they can't sell it without you anyway. So why would you need a Liz pendants unless you don't trust them? And then I guess you could. So, but mostly it is when you don't want someone to sell the property until your title issue is determined. Okay, you can't, and what is the effect? I wanted to go down here. Wait a minute. How do you file? I want to go, oh, I guess I didn't put them. But you can't I mean, a Liz pendants is only for when the issue is over title. So just because this guy owns a house and he owes you $100,000, you can't put a Liz pendants on his property. Money is money. What if he sells his property and he has the cash, it's the same thing as if, as far as a money judgment. So a Liz pendants can only be used when the issue is title to real property. Who owns it? Okay, if that's not the issue, then you can't use a Liz pendants. Okay. What's the effect? The effect is that it puts notice to the world, right? That there's a lawsuit over who owns this property. And if you're a buyer, you're certainly not going to buy a property from a seller who might not even own it. Because you're going to have to give it back if you know. So the whole idea is that if the public in general is not held to know what happens, things that happen in life, unless they're recorded, right? So if you don't record a Liz pendant, say you file a lawsuit for specific performance, you think that they should sell this property to you, right? And because you had an agreement and the seller breached it, so you file a lawsuit for specific performance and you don't file a Liz pendants. Well, that means the seller can now sell the property to somebody else who takes it in good faith because they don't know about the Liz pendants. It doesn't matter if the seller tells them, who probably won't tell them. because it has to be recorded. They have to have notice, and the title company has to have notice that there's a lis pendens. And if they don't, the lis pendens, the property could be sold by the time their specific performance action gets to court. I mean, that's the deal. Run and sell it as fast as you can sell it, because I mean, you could still be liable for money judgment, but you've sold your property and they have to find your money. So that's the whole idea, is that puts the world on notice that if they want to do something with this property, there is a lawsuit over it, and that they may not come out on the winning side. Okay, particularly relevant when appeals are, yeah, that's this example of these people. And then there was an appeal, and during the appeal, somebody named Jack comes in and buys the property, and Jack had to give it back because it turns out that Jack knew about the lis pendens. He thought it wouldn't matter, but he gambled wrong. And again, he couldn't have got title insurance, so I don't know. Okay, how do you file it? The lis pendens is just recorded just like any other recorded document that we have. It has to be notarized. It has to be signed. After signage, the notice must also be mailed to the parties, right? And you have to give notice to all the parties. Okay, can the court deny it? Yeah, the court can say two things. They can deny it on two reasons. The pleading doesn't assert a cause of action for ownership of real property. It's a nice pleading, but you're not saying you own the property. You're really saying that you're owed money. You can try to say that, but you're not saying it. And then the claimant has not established the probable validity. So if anyone can write anything, right? A lawsuit could allege anything. This property was given to us by so-and-so, and this person stole it from me, and I, whatever. They can say whatever they want, but they have to be able to establish some probable validity of their claim. The plaintiff, the person who has the lis pendens against them will come in and say, no, we got to get rid of this lis pendens. They made this stuff up. None of this stuff is true. And so the court, because this is a big deal to have your property encumbered by a lis pendens. And when you remove, just for lingo, when you remove a lis pendens, it's called expunging a lis pendens. I don't know why they just can't say remove it, but it's always a motion to expunge the lis pendens is a motion that says that they don't own the property. This is wrong. But it's called expunge, and I don't know why. It's probably some Latin word or something. Okay, any questions on lis pendenses? It's not really much to say because all they do is give notice.
So if one person says that someone fraudulently signed a document saying that the property belonged to another person, then that would be a title issue, right?
Right. Then you would go to the court. You would file a lawsuit to clear title, quiet title, and you would file a lis pendens. Because now you're saying I own this property and these people stole it. And gosh, we've seen that probably twice in the last year where we've had forged deeds in an escrow that we had.
So the person who thinks they own the property or originally owned the property and it was taken away from them, then they would file the lis pendens, right?
Correct. You have to have a lawsuit to file a lis pendens. You can't file it without a lawsuit. But they would file a lawsuit to quiet title, which says that you have title and I should have it. It's a little bit different. And then they file the lis pendens with that. That's the underlying lawsuit. Yeah. But I mean, lis pendens is, you can't sell your property, so they're. Although I've had people who just refuse to cancel even though lis pendens got filed. I don't get it. Okay, last one, specific performance. Okay, so specific performance is also statutory, which is why we have all these code sections. Basically it says, I have a contract to buy this house and you breached seller and I want to buy it. And we've seen it. We've seen sellers who have to cancel for all kinds of various reasons or just change their mind. And the buyer has this is again, an absolute right with us for specific performance, okay? Right. It is presumed that the breach of an agreement to transfer real property cannot be adequately relieved by money. Because every piece of property is unique. There are no two pieces of property the same. So because they're unique, if they refuse to sell you the property, money isn't going to help you any, because you can't buy this property unless they sell it to you. And another property is not the same thing. So that is why they allow a lawsuit for specific performance. There are very few contracts that you could specifically perform. In the case of a single family dwelling which the party seeking performance intends to occupy, the presumption is conclusive. That means absolute. Okay, so you have a single family home, the buyer is going to move in, it's not an investor, and the seller breaches, the buyer has an absolute right to require that the seller sell them the property. Okay, so a party who signed a written contract may be compelled specifically to perform it, though the other party has not signed it, even if the other party hasn't signed it, if the later has performed. So this would be a unilateral contract, and we don't really have those in real estate, where you say, I don't know how it's different than breach of contract, where you say, if you paint my house, I'll give you $500, and the other party doesn't sign anything, but they paint the house. But that's just a lawsuit. I think it's not specific performance. I don't know. I'm a little confused by that. Okay. A contract otherwise proper to be specifically enforced may be thus enforced, though a penalty is imposed or damages are liquidated for its breach. So you can have specific performance and damages, or specific performance, even if it causes like a seller to somehow be in have some sort of penalty. Okay, the following obligations can't be specifically performed. An obligation to render personal service. So if someone agrees to do something for you, you cannot specifically make them do it. Like a painter or a contractor, you just can't. And why would anyone want to? An obligation to employ another person in personal service. So again, you can't, if someone, I don't know, but you can't specifically perform these. That's kind of the same thing as the first one, if you ask me. An agreement to perform an act which the party has not power lawful. Oh yeah, this is language weird. Which the party has not power lawfully to perform. Okay, so an agreement to perform an act which you can't lawfully perform. An agreement to procure the act or consent of the wife. This is awful. The agreement to procure the act or consent of the wife of the contracting party or any third person. What? Why would it say wife and not spouse? Unless it's been here forever and no one even knows it's here besides us. But anyway, you can't, again, this is all personal services. You can't make somebody do something. An agreement, the terms of which are not sufficiently certain to make a precise act. Okay, so it has to be an agreement certain. You can't have a vague agreement that everyone who looks at it doesn't say, yes, this is what this is. Okay, it can't be vague. Okay. Specific performance cannot be enforced against a party to a contract if in the following cases. If they have not received adequate consideration for the contract. So somehow you get this person to pay $1 million for, a little shack, and they say, no, the other way around. You got a big, I don't know. Anyway, there has to be adequate consideration, and in our industry, there usually is. There big money in a house, there usually is. That's not going to be an issue for us. If it is not, as to him, just and reasonable. Where is this coming from? Okay, if it's not just and reasonable, so no court is going to do something that's not just and reasonable. This is an equitable cause of action, and so they're going to act equitable in when they decide. It would become due, or if why does it say his? Boy, oh boy, I'm going to write to them. If his assent was obtained by the misrepresentation, concealment, circumvention, or unfair practices. So obviously, if you consented because of that, again, under the influence of mistake or surprise, and specific performance cannot be enforced in favor of a party who has not fully and fairly performed. So this is the one that probably affects us the most. The party, if they're a seller, you have to fully and fairly perform, although sellers don't always have a lot to perform. All the conditions precedent to make them have to close. So if you have an agreement, seller, that you are going to repair the roof or repair something else, in order to force them to, to close the sale, you are going to have to do that too. You're going to have to do your part. Okay, can a seller enforce, can a seller sue a buyer for specific performance? A seller also has a legal right to bring an action for specific performance against a defaulting buyer. Many real property purchase agreements, okay, so under the law you can. A seller can also sue a buyer to finish it. However, in our contract, we have a liquidated damages clause that everyone is familiar with. And when there's a liquidated damages clause, it says that if the buyer defaults, the only thing the seller can get is the deposit actually paid, right? And so that probably is an exclusive remedy that that takes us out of that. If that's in your contract, then you can't sue for specific performance because you've agreed that if they breach, that's the most you can get, or the only thing you can get. So as long as there's a liquidated damages clause, a seller cannot make a buyer perform. Okay, what are the damages? So now we've gone in, we've brought specific performance. What else can the court do? Okay. The buyer may also obtain a damage award for consequential damages. So the buyer is not stuck with just, I get to buy the property. By the way, here's all my damages because you didn't let me, right? Interest rates went up. This went up. Something, my insurance went up. Back then I got quoted this, now I'm being quoted that. So those are all damages that a buyer who brings a specific performance action can recover, in addition to getting to buy the property. So seller, you're just getting yourself into trouble by fighting this. And this is another cause of action, very much like the other one, that once you get a good lawyer, they're going to tell you that you're going to lose and you might as well sell it to the buyer. Right. And that's happened in many times with us, is where the seller is adamant, the buyer files a lawsuit, and the buyer and the seller's right away like, fine, I'll sell it because I know I'm going to lose. Because why spend money in court when they have an absolute right to buy the property? So hopefully that's what happens most of the time. Yes, you could file a lis pendens with a specific performance action. And of course you would have to. There would be no reason not to file a lis pendens because otherwise the property could be gone by the time you get the court to say you could buy it. So you don't want that. Okay, any questions on specific performance? Is everyone sleeping?
So Cindy, question for you, sweetie. So why is it that on our contract on the buyer, if the buyer changes their mind, the seller can sue the buyer?
Not if there's liquidated damages.
Right. But why is it that if the seller changes their mind, they still have to go through this process?
Because there's nothing in our contract that limits the damages against the seller. Sure, could CAR put in the contract?
Yeah.
That the party, because you can waive this, you can waive your right. Can the parties waive their right to specific performance? They could, but they don't.
Yeah. Why is that?
Because
almost like it's not fair.
The idea is that, I guess we favor buyers a little more than we favor sellers. If the buyer wants to buy the house. And again, what's going to matter is going to matter whether or not they're going to live in the house. Right? Because the absolute right is only for people who intend to occupy. Because that's what the courts are trying to, that's what we're trying to promote, is people want to buy houses to live there. We like rental houses too, because people get to live there too, but that's what they're trying to, gee, you bought this house, you fell in love with this house, you purchased it, and the seller friggin' changed his mind.
Yeah.
No, sorry, seller. But honestly, I don't have any numbers on this, but my guess would be is that, it's 1 in 10,000 that file, or 1 in 5,000 that file a lawsuit for a specific performance. Most people don't want to wait that long. That means you have to wait, you have to go file it, you have to wait until the court, and you're sitting around and you can't buy another house. And so, do you want to do that? So we don't see it. We don't hear about a lot of them. We maybe 5 a year, maybe 4. Something like that. I don't know that I hear about all of them either, but that's about what I hear. But these are remedies, and so this is the whole point of today was to educate you so that you can look smart when your clients ask you these questions.
Yeah.
And I'll be sending this out so you can refer back to it. And if anyone has any questions about this or anything else, I'm here.
Thank you, Cindy.
Just you have time to talk.
Thank you.
Thank you.
Thank you, Cindy.
Thanks, Cindy.
Thank you, Cindy.
Thank you.